NTA blog. Summary. Appeals improves alternative dispute resolution programs, but barriers remain. The IRS's alternative dispute resolution (ADR) programs, such as Fast Track Settlement (FTS) and Post Appeals Mediation (PAM), offer faster, more collaborative ways to resolve tax disputes outside of traditional appeals or litigation. These programs are voluntary, confidential, and preserve taxpayer appeal rights if no agreement is reached. After years of underuse, ADR participation increased significantly in 2024, with ADR case volume up 25%, PAM cases up 110%. In LBNI and SBSE divisions, FTS resolved issues faster than traditional appeals, with over 89 to 91% agreement rates. The IRS launched new pilot programs and an ADR program management office to expand access and promote use. However, key barriers remain. IRS compliance staff must agree to ADR, and many are still reluctant. Low-income taxpayers, especially those in correspondence audits, are generally excluded from ADR due to structural limitations. The Taxpayer Advocate Service, TAS, urges the IRS to provide training to IRS staff on ADR benefits. Create new low-cost ADR options for low-income taxpayers. Consider reviving binding arbitration for complex cases that taxpayers cannot litigate. Conclusion. IRS appeals ADR programs provide taxpayers with mediation options that yield expedited case resolutions as an alternative to traditional dispute resolution. However, these programs have been historically underutilized by taxpayers for several reasons. Recently, appeals and the IRS have taken steps to change the tide, and taxpayers are exercising their ADR options at a higher rate. Meanwhile, Appeals has initiated pilot programs that modify the rules surrounding the programs, making them more accessible to taxpayers, but it will take IRS compliance functions some time to fully embrace new ADR procedures. Both the IRS and Appeals should develop comprehensive training that clearly sets forth the benefits of ADR for both the IRS and taxpayers, namely, a faster resolution of the issues in dispute. Further, the IRS and Appeals should continue to work with TAS to investigate other areas where it could expand ADR or ADR-type programs to low-income taxpayers who would greatly benefit from another fast and efficient way by which they could have their issues heard and resolved. By continuing to modernize and promote ADR programs, the IRS can better serve taxpayers at all income levels while improving efficiency and trust in the tax system.
The views expressed in this blog are solely those of the National Taxpayer Advocate. The National Taxpayer Advocate presents an independent taxpayer perspective that does not necessarily reflect the position of the IRS, the Treasury Department, or the Office of Management and Budget. You have listened to a summarized audio version of the NTA blog. This is a computer-generated AI voice narration. Inconsistencies in pronunciation and tone may occur.